This session is more than mere coverage of academic thrust area. It is rather a session for all the citizens of India, because all the citizens must have basic awareness about their rights, because rights are the pillars of any mature democracy. The preamble to the Constitution of India establishes that in India, democracy emphasizes on rights and dignified existence of the people. It is our duty to enrich our legal resources and know our rights. Fundamental rights in India have been ensured by its part 3 of the Constitution. Indian Constitution has guaranteed some legal and some fundamental rights to its citizens. Even the residents, that is, who are not the citizens of India, are being given certain basic rights like right to equality, right to worship, etc. An elaborate list of fundamental rights has been incorporated in the Part 3 of the Constitution. Part 3 of the Constitution is like a charter of rights contained in the Constitution of India. What it guarantees? It guarantees civil liberties in such a way that all the Indians can lead their lives in peace and harmony as citizens of India. Let us start with the definition of fundamental rights. The rights which are considered essential for the development of the personality of every individual and protection of human dignity are known as fundamental rights. So, these rights are essential for the development of the individual self of every citizen of India. On the basis of above definition, what we can say? We can say that fundamental rights protect citizens against any sort of arbitrary or absolute exercise of power by the state. Fundamental rights help upholding basic human rights, which are absolutely necessary for the development of the personality of the people. So, fundamental rights are derived from the enumerations of human rights. Fundamental rights, as enumerated in Part 3 of the Constitution, focus on the need for assuring fundamental unity of the nation by guaranteeing the access and use of same facilities and rights to all the citizens, irrespective of their caste, creed, religion, sex, and any other sort of discrimination. There is a specific feature of Indian Constitution as visible in its Part 3. The Constitution guarantees rights of the individual against the state as well as against any private individual. That is, neither the state nor any individual shall have the right to violate the rights of others. These rights are available to the resident as well as non-resident citizens of India. Some rights are there which are available to the residents of India who are even not the citizens of the country. The Constitution also guarantees the rights of minorities against the majority. Though democracy is a rule of majority power, still Indian Constitution guarantees the rule of the minorities, which is a very unique feature of our Constitution. The Indian Constitution has guaranteed some legal and some fundamental rights to citizens, as I have already said. Certain other social and economic rights are there which are being enumerated in Part 4 of the Constitution, that is in the chapter covering directive principles. Now, what is the difference between Part 3 of the Constitution and Part 4 of the Constitution? Part 3 of the Constitution enumerates certain rights which are justiciable. That is, any citizen, even in certain cases the residents of India, can move to the court of law against any sort of violation or infringement of his or her rights. Part 4 is a non-justiciable part. That is, it is enumeration of certain directives to the state, that is the government, for assuring or ensuring certain social and economic rights to the people. As I have already said that some fundamental rights are meant for all the residents of India, whereas others are available only to the citizens of India. Indian constitution has guaranteed certain legal and certain political rights. Let us give some example. Right to life and personal liberty is available to all the people. So is the right to freedom of religion. On the other hand, freedom of speech and expression, freedom to reside and settle in any part of the country are reserved to the citizens alone, including non-resident Indian citizens, but not merely the residents who are not the citizens of India. The right to equality in matters of public employment cannot be conferred to overseas citizens of India. The framers of the Constitution regarded that civil liberties are the main pillars of democracy, which must be duly recognized and protected by the state. The development of constitutionally guaranteed fundamental human rights in India was inspired by certain other enumerations which we adopted from some foreign constitutions. 1. England's Bill of Rights, which was adopted in 1689 following glorious revolution. The United States Bill of Rights, which was approved on 17 September 1787, finally ratified on 15 December 1791. France's Declaration of the Rights of Man, which was created during the French Revolution of 1789, and it was further ratified on 26 August 1789. Apart from this, British educational system had profound impact on the evolution of the chapter of fundamental rights. British educational system exposed Indian students to the ideas of democracy, human rights, parliamentary democracy, etc. Especially Jeremy Bentham, James Mill, and more prominently John Stuart Mill's ideas on liberty and such other concepts had profound impact on the thoughts and ideas of educated Indians. And these educated Indians later on the constituent parts of the Constituent Assembly of India, which actually drafted the Constitution of India. In 1931, the Indian National Congress, which was the largest Indian political party of the time, adopted resolution committing itself to the defense of fundamental civil liberties as well as socio-economic rights of the people, such as minimum wage, the abolition of untouchability and serfdom, freedom of religion, etc. The Constituent Assembly first met on December 9, 1946, and while the members of Congress composed of a large majority, Congress leaders actually nominated persons from diverse socio-economic groups. There were representations from various religious communities as well as various social and economic sections of India. And thus, the chapter on fundamental rights was designed as to cover the needs of the people of all these sections of the Indian population. B.R. Ambedkar became the chairperson of the drafting committee. Jawaharlal Nehru, Sardar Vallabhbhai Patel, they became chairpersons of several other committees and subcommittees. They were all eager to make our constitution as a truly representative entity of the Indian people. Therefore, Indian constitution tried to represent views of all the minority sections of the community as well as of the majority. In the meantime, the United Nations General Assembly adopted the Universal Declaration of Human Rights on 10th December 1948, and it called upon all the member states to adopt these rights in their respective constitutions. In India, the fundamental rights were included in the first draft constitution prepared in the month of February 1948, and finally they were adopted as part of the constitution on 26th November 1949. These included individual rights common to most of the liberal democratic countries of the world. So far as the debates in the Constituent Assembly are concerned, it can be said that the debate on fundamental rights took a major portion of time in these debates. Let's highlight certain basic features or attributes of fundamental rights. Fundamental rights are essential for the development of the personality of every individual and protection of human dignity. The fundamental rights were included in the Constitution because they were meant to protect the very spirit of democracy. Democracy is a rule by the people, for the people, and of the people. So, the people must be aware of their rights and dignity. Unless the people are given adequate rights, state cannot ask them to perform their duties towards the government, towards the nation. So, these fundamental rights are obviously indispensable parts of democracy which are to be duly recognized and protected by the state. So, fundamental rights primarily protect the individuals from the state and from any arbitrary actions taken by the government, as well as any sort of infringement or violation on part of any private individual. For instance, the Constitution abolishes untouchability and also prohibits beggar. These provisions act as a check both on the state action as well as action of private individuals. However, these rights are not absolute. These rights are not uncontrolled. They are subject to reasonable restrictions as necessary for the protection of general welfare of the nation. They can also be severely or selectively curtailed as the time and occasion permits. Since the fundamental rights can only be altered by a constitutional amendment, their inclusion is a check not only on the arbitrary decision of the executive branch of the government but also on the parliament and the state legislature. The fundamental rights are defined as basic human freedoms which are necessary for a proper and harmonious development of personality. What did Aristotle say? Aristotle said that it is necessary to be a good person, but every good person can never be a good citizen. Then what is the definition of a good citizen? The citizen who is one who is aware of his rights, who can make his government accountable to perform its duties properly. And this is the essence where the importance of this chapter lies in. Fundamental rights are enforceable in the courts of law. That is, Part 3 of the Constitution is justiciable. Any sort of violation of fundamental rights can be addressed by the court. There are specifically one fundamental right which is known as right to constitutional remedy, covered by Article 32 of the Constitution. In this Article 32, it has been said that if there is any sort of violation of our fundamental right, we can move to the Supreme Court for enforcement of this fundamental right. There is another provision, that is Article 226. By using this Article 226, one can move to the High Court of a concerned state if he feels that his or her rights are being violated within the jurisdiction of that concerned state. Another thing we must remember, that both the Supreme Court and the High Courts can issue writs. There are 5 writs like habeas corpus, mandamus, quo warranto, prohibition, certiorari. These writs are applied by the Supreme Court as well as by the High Court for enforcement of these fundamental rights. Now, Part 3 of the Constitution enumerates following rights. Right to equality. It is being covered by Article 14 to 18. All persons, what it says? It says that all persons are equal before the law. What does it mean? This means that all persons shall equally be protected by the law of the country. It also states that no citizen shall be discriminated against on the basis of their religion, race, sex, creed, caste, etc. Every person has access to all public places, including playgrounds, hotels, restaurants, shops, etc. The state cannot discriminate against anyone in matters of employment in any government office. Article 17 of the Constitution abolishes the practice of untouchability. It says that practice of untouchability is an offense and it is punishable by a law of the land and Indian Penal Code. Article 18, it abolishes any sort of acceptance of titles like Rai Bahadur, Khan Bahadur, etc. Right to freedom. It is being covered by Article 19 to Article 22. This covers the right to freedom of speech and expression, right to form associations, right to move freely and reside in any part of the country, and right to practice any profession, take any occupation or business. There was another right, Article 19, Clause F, right to property. This has been abolished in the year 1978. It has inserted another right, that is Article 21A. In 2002, through 86th Amendment Act, Article 21A has been incorporated. It says that the state shall provide free and compulsory education to all the children of the age of 6 to 14 years in such manner as the state may by law determine. Right against exploitation. It is being covered by Article 23 and Article 24. The Constitution prohibits trafficking, forced labor, prohibits child labor, and protects children from working in any hazardous job who are below 14 years of age. Right to freedom of religion. In the preamble, we have already taken an oath that we shall go for establishing a secular state. And this particular declaration is being strengthened by Article 25 to 28, 25, 26, 27, 28. These 4 articles actually ensures religious freedom. Religious freedom means that every person has the right to practice, profess, and propagate the religion of their own choice. And herein lies the essence of secularism in India. That is, state neither declares any religion as its state religion. State is indifferent or impartial to all the religions that the people of the country wants to follow. Cultural and educational rights. It is being covered by Article 29 and 30. The Constitution states that all minorities, religious or linguistic, can set up their own educational institutions in order to preserve and develop their own culture. Right to constitutional remedies, it is being given by Article 32. As I have already said, that these fundamental rights, this is the part 3 of the Constitution, it is having a very unique feature. We can move to the court of law for enforcement of our right. And if we move to the court of law, we can seek for writs. We can ask for writs, and petitions can be moved for enforcement of writs for enforcement of fundamental rights. The Supreme Court and the High Courts both can ensure our fundamental rights, as I have already said, but so far as the Supreme Court is concerned, it can it can apply writs for the enforcement of our fundamental rights under Article 32, that is, right to constitutional remedy. There are reasonable restrictions to all these rights and in all cases. One thing I must tell you, that right to property. Right to property was previously being covered by Article 31. Originally, it was a fundamental right, but it has been omitted by 44th Amendment Act 1978. It is now a legal right, is a constitutional right, but not a fundamental right. It is being covered by Article 300A, which says that no person can be deprived of his property save by law. Articles 12 to 35, this area is covered by Part 3 of the Constitution. These are the important part of the Constitution or treasure of democracy. But these rights can sometimes be suspended if there is a national emergency. Under Article 352, the rights conferred by Article 19, that is freedom of speech, assembly, movement, etc., remain suspended. Right to move court for the enforcement of other rights may also be suspended by order of the President if there is a proclamation of emergency under Article 352. 352 talks about national emergency. In 1975, India faced such a situation. There was national emergency and our rights suffered a lot. Justice H.R. Khanna in 1976, he refused to support the government for infringement of rights. And he said that I spent a sleepless night but could not go against the freedom of speech and expression to be used by the citizens of India. So these under national emergency, maybe for the security of the nation, maybe for the greater national interest, fundamental rights remain suspended, which implies that during that period, India becomes a non-democratic entity, an authoritarian state, because rights are being left with the discretion of the ruling party. So these are the basic feature of fundamental rights, and these basic feature of fundamental rights suggest that except during emergency, India has nurtured well the essence of its democratic flavor.